Hello and welcome to first, but for sure not last, LOMAD Animated Series. We're going to talk about the third department case, 2018, Yonkosky v.Town of Hamburg. Here, the claimant worked as a laborer for a municipal highway department for approximately 3 months during the summer of 2014. His duties involved working with crews to clear roadside brush and fill potholes with asphalt. In July 2014, he began experiencing problems with his right shoulder and sought treatment from a chiropractor who advised him to take a week off work. After a brief period of rest, the symptoms resolved and he resumed his duties until the end of the summer, returning to college. However, in December 2014, while playing basketball, the claimant's symptoms resurfaced. He consulted an orthopedic specialist where diagnostic imaging revealed a torn right rotator cuff. In January 2015, the claimant filed for workers' compensation benefits, claiming he injured his shoulder on July 24, 2014, while tipping a wheelbarrow to unload asphalt into a pothole. The self-insured employer disputed the claim. Following various hearings, a workers' compensation law judge ruled in favor of the claimant, establishing the claim as an occupational disease and awarding benefits. This decision was affirmed by the Workers' Compensation Board, prompting the employer to appeal. The employer contended that the evidence did not support the board's classification of the claim as an occupational disease, asserting that it should be considered an accidental injury, making it untimely under Workers' Compensation Law, Article 18. According to the law, an occupational disease is defined as a disease contracted through the nature of employment. To establish such claim, the claimant must demonstrate a recognizable link between their affliction and a distinctive feature of their employment. The third department reviewed the case and observed that the claimant testified that while he was unsure of when the injury occurred, he felt a twinge in his shoulder while emptying a wheelbarrow over asphalt around July 24th. Although his supervisor noted that the claimant primarily worked on the brush clearing crew, the specific duties were never detailed. The chiropractor testified about treating the claimant for spine issues but did not examine his shoulder. The treating orthopedic acknowledged that the rotator cuff tear was unusual for someone in their 20s and stated it could result from either repetitive overhead activities or a single traumatic event, but he could not determine the exact cause in this case. Upon reviewing of all evidence and testimony on the record, third department agreed with the employer, noting that the injury should be classified as an accident, as the proof failed to demonstrate that the claimant's shoulder injury was attributable to repetitive movements associated with moving heavy wheelbarrow loads of asphalt or performing other manual duties. Therefore, the classification of the injury as an occupational disease lacks substantial evidence, and the third department ultimately decided that the board's decision that this is an occupational disease must be reversed, as there is insufficient evidence to establish a recognizable link between the shoulder injury and the distinctive feature of the claimant's job. So this case is a perfect example that difference between the accident and occupational disease is not just there just because, but it's also very important, for example, when you want to argue whether the certain claim has been untimely reported under Workers' Compensation Law, Article 18. Thank you for listening and see you next time.